Good afternoon, everyone. My name is John Cornwell, and I'm the Director of Marketing and Business Development here at Plunkett Cooney. It's my pleasure to serve as coordinator for today's webinar, so let me begin by welcoming everyone. Today's topic about unusual cases and uncommon defenses is certainly an intriguing one, so we hope you leave today's webinar with some good takeaways. Before we get started, I just want to take a few moments to provide you some background about our law firm. For those of you who don't know, Plunkett Cooney is based in Southeast Michigan and is one of the Midwest's oldest and most accomplished law firms with approximately 140 attorneys and 8 offices throughout Michigan. And we also have offices in Chicago, Illinois, Columbus, Ohio, and Indianapolis, Indiana. Our Tort and Litigation Practice Group is comprised of attorneys from across the region who focus their practice on various aspects of general liability, retail liability, premises liability, dram shop law, and other related areas of litigation. Our attorneys routinely defend cases involving retailers, food service, and hospitality business owners, commercial property owners, and other businesses insured by some of the world's leading insurance providers. Joining me today are two of Plunkett Cooney's most experienced attorneys in this nuanced area of Michigan law, Rick Simchek and Abe Barlowskar, both of whom work here in our Bloomfield Hills office. Rick's been practicing for 40 years now, with 24 of them right here at good old Plunkett Cooney. He's a member of Michigan Defense Trial Council and DRI, formerly the Defense Research Institute. He has a diverse practice that includes claims involving premises liability, insurance coverage, motor vehicle liability, title insurance, and banking law. Rick works closely with policyholders of some of the nation's largest insurance providers to resolve often complex and high exposure matters. Abe's also a member of the Tort and Litigation Practice Group, who has a diverse practice that includes all aspects of general and premises liability, as well as third and first party auto liability. Additionally, his practice includes retail liability, foodborne illness cases, and declaration actions and fraud cases involving coverage disputes, as well as actions for claim and delivery. He's a member of the Insurance Fraud Committee of CLM, the Claims and Litigation Management Alliance, and he serves as chair of CLM's adjuster training courses. Before we get started, I've been asked to cover just a couple of housekeeping items for today's program. At the end of the webinar, we'll take as many questions as time permits. If you want to ask a question, simply type it into the GoToWebinar questions window located on your webinar desktop. Please note that today's session is being recorded, and that recording will be available on Plunkett Cooney's website located at plunkettcooney.com. Once again, on behalf of the firm, thanks for attending today's webinar. Now let's get things started. Rick, I believe you are up first, so take it away.
I am up first. I want to thank folks attending this webinar. We hope to share with you something a little different today. We've titled this Uncommon Defenses because they aren't common. These are the more rare, more esoteric, different things that we can encounter in the defensive matters. Too often, defenses are just the usual suspects, just the boilerplate that we place in the laundry list of affirmative defenses that follows our answer. But it's sometimes the case that very particular facts may trigger the application of an unusual defense, something out of a statute or case law that can become the centerpiece of a defense and a defendant's strategy if the facts are there. Because their relevance so often depends on particular facts, they're not often the first defenses that come to mind. Nevertheless, good defense counsel, aggressive defense counsel, has to be aware of these infrequently encountered defenses and has to be on the lookout for the opportunity to raise them in their vigorous defense. And with that, I turn this over to Abe.
All right, Abe here. Today we're going to be discussing and addressing uncommon defenses of intoxication issues, assumption of risk, wrongful conduct, and the sudden emergency doctrine. There's a statute on point MCL 600.2955A, and it is an absolute defense when an injury is caused because of the use of either the alcohol or substance. Although the statute says intoxicating liquor, that does include alcohol, and because of the impaired ability, the injured person was 50% or more the cause of the accident. And with intoxication issues, if an intoxicated person was less than 50% at fault, then their damages are reduced by that percentage, and that's to be determined by a jury. Intoxicating liquor is the slide that you have before you. Intoxicating liquor also includes beer, wine, and is not just limited to liquor. And then we've got Controlled substances. Controlled substances are defined by the Michigan Health Code. And a controlled substance means a drug, substance, or immediate precursor included in Schedules 1 to 5. And there is the Health Code definition. In summary, a controlled substance is defined as a substance that has a narcotic, stimulant, depressant, or hallucinogenic effect on the central nervous system, as those that are defined as Scheduled 1 and Schedule 2 controlled substances under the Health Code. So some examples of scheduled drug classifications in Michigan. So for Schedule 1 controlled substances, it would include things like LSD, ecstasy, mushrooms, heroin. Schedule 2 controlled substances include things such as cocaine, opium, high-potency morphine, oxycodone, and methamphetamines. And then we've got Schedule 3 controlled substances, which include lower-potency morphine, steroids such as ketamine, and some codeine mixtures. Schedule 4 controlled substances include examples such as Rufinol, Valium, Xanax. Those are prescribed, at least the second two are, Valium and Xanax are. And Schedule 5, which are probably the most prescribed, include mixtures of medicines containing codeine, like if you would think Tylenol 3 with codeine or cough syrup with codeine, and some medications with mixtures of low dosages of opium. So here we have the statute, which defines impaired ability, and that's defined as an impaired ability means that the injured person is impaired to the point where their reaction time is diminished because of the use of the alcohol or substance. And the MCL 600.29558 continues that there's a presumption of impairment if that person could have been charged for impaired driving under the Michigan Motor Vehicle Code. And that's not limited to alcohol. It can include marijuana. It can include high dosages of Xanax or Valium or anything else that could impair a person's ability to operate a motor vehicle code. We do have a Michigan civil jury instruction on intoxication, and the jury instruction essentially leaves it up to the fact finder, which ordinarily is a jury, to determine if the use of alcohol was a factor, and if so, by what percentage it contributed to the accident. Next, you've got a civil jury instruction for violation of a statute regarding negligence. This jury instruction applies to both plaintiffs and defendants and allows the jury to determine whether the violation of statute is deemed to be negligent. If after the jury determines that the violation was negligent, then the jury must make a determination whether that negligence was a proximate cause of the accident, not the proximate cause, but a proximate cause. So going to alcohol use, ways to determine whether alcohol use contributed to the actual accident, whether it's someone falling off a roof or a motor vehicle accident or a slip and fall. Typically, we can have witness statements if there are witnesses, if there's a police report for a DUI or suspected DUI, typically there's a PBT, which is a roadside preliminary breath test. And if a person refuses that, they're typically, at least in Michigan, taken to the station where either their blood is drawn or they blow into what's known as a data master. Other things to look at are medical records for ETOH, which is alcohol. And if a person in a motor vehicle accident is alleged to have been drinking and driving and is charged, there may be bond conditions. It's important to look at the bond conditions and if there's any sort of limitations on drinking. At least in Michigan, most of those conditions are placed by the judge, and a person has to go to a facility, typically the sheriff's office, to do what they call an ETG test, which tests for alcohol in the urine, which is a metabolite that's left over from consuming alcohol. So typically that goes back 72 hours before the ETG test is done. And other places to look are obviously drug screening and blood test work.
This is the next step in research, especially with regard to the legalization of marijuana for both recreational and medical uses. Here we have the report on the University of Pittsburgh's Department of Chemistry, where they've developed a breathalyzer for tetrahydrocannabinol, which is the active ingredient in marijuana. This is, and has the potential to be, a very significant development, as they are looking at this truly as a breathalyzer for marijuana, which is now going to become a legalized drug of choice. So looking at this, we see this as the cutting edge in terms of investigation and in terms of developing a defense for marijuana as an intoxicant. We really do expect that the prototype is going to be available within the next 2 years. It's still in testing, but we do anticipate that the University of Pittsburgh is going to market this out to police agencies in the very, very near future. Trying to apply a practical approach to these uncommon defenses, we're going to look at a fact pattern here involving a college town in the Midwest. The names have been changed and omitted to protect the embarrassed, and we're going to show you how the defenses intersect with the fact pattern and the liabilities involved. The photograph is of a mixed commercial use building in a downtown college town. As you can see, there are a number of students on the second story balcony overlooking the street, all of whom are engaging in what is, my children have called, pregame. This was a football afternoon. Everyone there is having a very good time, and you can see in their hands somewhat why. Much beer, much wine was flowing at this particular event. One of the tenants, one of the students living in the residential part on the second and third stories of this building was sitting on the canopy that you can see at the edge of the roof. As he sat there, he lost his balance and fell 12 feet down to land on the sidewalk. That was the beginning of a very tragic series of events. Landing on the sidewalk, he sustained massive brain spinal injuries. His eventual treatment for several months at the University Hospital incurred $800,000 in medical bills. Amongst the records was the drug screen done at the hospital, which showed a 0.18 blood alcohol. This is 0.08 above what would be the legal limit here in Michigan now. Likewise, he was a freshman. He was 18. It makes him underage. It makes his consumption of alcohol, in this instance, illegal, and therefore wrongful conduct. The complication was this particular structure did not have a guardrail protecting the individuals on the second story. This created a complication in the defense because we have the interplay between the intoxicated underage individual breaking the law, and we have the dangerous condition, which is perhaps open and obvious, but perhaps because it's a non-compliant with a statute or an ordinance, not necessarily open and obvious. You have a mixed-use building, you have significant injuries, and you have the real interplay between these two defenses and what is, in many ways, an extraordinarily sympathetic and compelling case. On top of that, there was only $1 million in coverage for the property owner, and who was likewise the landlord and therefore owed the duty to the freshman as the tenant. But the building was worth $3 million. Under the circumstances, the collectible defendant was very much exposed in this case, given the fact that merely the medical specials alone were $800,000, and under the old rule of thumb of potentially valuing the case at 3 times specials, it would have been a $2.4 million demand expected. In this instance, discretion was the better part of valor. This is a matter that was resolved, but you can see how one had to be conscious not merely of intoxication, but violation of the law by both the plaintiff and potentially by the defendant property owner for not having the appropriate guardrail. Hopefully this illustrates the depth with which cases have to be investigated in order to find the uncommon defense.
All right, next we talk about legalized cannabis and marijuana. As Rick mentioned, it is legal to recreationally use marijuana. So some of the places to start are looking at the hospital drug screens. If it's a serious injury, typically they draw blood and they'll test for THC. Obviously part of the deposition to ask questions about marijuana use and other prescription drug use. In Michigan, we've got the Michigan Automated Prescription System, which tracks prescribed drugs and filled controlled substances, including the date they were prescribed, the dates they were filled, which doctor prescribed them, which pharmacist filled them. So the doctors can be deposed, the pharmacists can be deposed, and if there's any tox screenings to see if the person was actually using the drugs rather than filling them and selling them. And then the last bullet point on this slide talks about retaining a toxicologist for an opinion. I'd also like to add that sometimes when a person comes in after an accident, a neurologist may come if there's any kind of potential traumatic brain injury or brain injury, and they do a test using sort of like a police officer would use on a roadside test to see if a person was impaired. It's called the HGN, horizontal gaze nystagmus, and that checks to see if a person's intoxicated using alcohol. Now, typically neurologists also do vertical gaze nystagmus, and if they can find nystagmus, that's usually a sign of impairment from drugs, which include marijuana. So for that, I would say not only retain a toxicologist, but also a neurologist to determine what the cause of the nystagmus was.
Okay. Stepping into our second topic, assumption of the risk. Much as it sounds, it's assuming the risk of injury by engaging in a particular activity. This has not really been a popular defense since 1965, when the Michigan Supreme Court said it wouldn't apply in most ordinary negligence actions. But to understand it, we can even refer back to the old Latin phrase, volenti non fit injuria, or to a willing person, wrong is not done. I'm the old lawyer, so I had to refer to the Latin. But on a practical basis, we have the mixed martial artist who's engaged in a match. How can he claim injuries for what's obviously going to be inflicted anytime you've seen a match on TV? We know exactly how dangerous it can be for either of the participants. Under the circumstances, that's a person who's not going to have a claim against the organizer, the other participant, or any of the other potentially liable defendants for putting on that kind of display. When we get to the issues like the pickup basketball game on a YMCA court, or a informal guys get together, play hockey kind of thing, we do have a new line of demarcation in terms of liability, and that line of demarcation is recklessness, as distinguished from carelessness. But there's also the issue of, well, what about the inherently dangerous activities like skiing? Ordinarily, those types, like skiing, you have an organized activity done in a formal setting where very often in order to get on the slope, you have to sign the waiver first. So that changes the dynamic in that instance. Zip line is another good example, not a contact sport, but certainly an inherently dangerous activity. I can share with you that right now there's a case out in New York where AIG is disputing with Carnival Cruise Lines with regard to zip lining on the ocean liner, and whether that claim brought by the passenger on the cruise line has to be arbitrated in accordance with the agreement signed before the person got on the zip line. And of course, again, a very tragic circumstance and set of events, because that woman is paralyzed. Again, re-emphasizing the inherent danger in something that's not really a sporting activity, but is most definitely kind of exciting. Likewise, indoor rock climbing. We actually have case law in this now in terms of the assumption of the risk, but the focus is on the plaintiff having expressly contracted to assume the risk. So again, somebody in an organized activity who signs a paper that says, yes, I'm going to rock climb, I am going to be spotted, but I'm going to hold the organizer or the event sponsor or the owner of the, in this case, it was an amusement park, we're going to hold them harmless. Again, case law says this is an express assumption of the risk, and therefore the injured plaintiff was essentially waived his rights. Again, with a particular emphasis on practical events and real life circumstances, we're going to talk about open wheel car racing. You can sort of see in the photograph that the wheels and axle and the ends of the axles project out from the body of the car. And that becomes critical because it presents an obvious risk that in a crash, those parts are going to become loose and become potential missiles and spears. In this particular instance, a crash caused the breaking of an axle to come away from one car and penetrate the engine compartment and then the passenger compartment of the second vehicle. In doing so, it essentially speared the driver of the second vehicle at the point of the knee, went off, the axle went all the way up his thigh into his hip, causing significant injuries, had to be removed from the field, taken to hospital where he spent several months, first of all being operated on 3 occasions, and then finally going through extensive rehab. In this particular instance, again, a formally organized event, a race, an experienced driver, but in this instance, even though the driver admitted that he'd always signed a waiver before, the specific waiver for this driver could never be located. So it became a question of fact as to whether he had actually assumed the risk because there was no written waiver, even though he certainly knew the risks and had signed waivers on all of his other previous races. Complicating the matter is the individual plaintiff in this case was a truck driver. As a truck driver, given this injury, he was prevented from being able to climb into the cab of his over-the-road 16-wheeler, which essentially disabled him for life from his chosen profession. In this particular instance, the risks were obvious. The assumption of the risk should have happened, but in a circumstance where a waiver was available and never executed, it created a significant problem for the defense. So the waiver is essentially a contractual assumption of the risk in this instance, but it's not the only way that risk can be assumed, especially in cases where we have things that are almost inherently dangerous, like zip lining and skiing, even to the pickup hockey game. So in looking at that, the case law assumption of the risk as opposed to the formal law, either statutory or contractual assumption of the risk, the distinction is carelessness versus recklessness. Now, very often we use the dictionary definition that talks about recklessness is defined as unconcerned about consequences, but again uses the term carelessness. Dictionary definitions for non-defined terms are an accepted method of interpretation under Michigan law. This becomes a little bit confusing when you see reckless and careless being used interchangeably in this particular definition. But case law is going on to talk about carelessness, recklessness as exceeding the level of carelessness which most people accept as part of the actual activity. It's the difference between being slashed with the hockey stick or the hockey stick being swung or the gloves coming off and an actual fight breaking out in the hockey game. When we talk about this, we talk about people being engaged in something that has inherent risks, that there is a duty between the individuals to not act recklessly. But again, the standard of care acknowledges that it has to be an injury that arises from a risk inherent to the activity. So an understanding of the activity and the dangers it presents simply by virtue of participation in it is absolutely necessary to the defense. In one particular case, we had an individual who was hiking on a trail who was struck by a trail bike. In this particular instance, we had the hiker and the biker. Because they weren't engaged in the very same or identical activity, the assumption of the risk wouldn't apply in this instance. Recklessness was not even a consideration beyond that, and because of that, the case went forward with the biker being liable to the hiker because they were engaged in two different events, and the hiker couldn't be assumed to have assumed the risk in this instance.
Okay, next we're going to talk about the elements of the wrongful conduct rule. The elements of the wrongful conduct rule is that the plaintiff's conduct must not merely be illegal, but prohibited or almost entirely prohibited under a penal or criminal statute. Interestingly, Rick and I were talking about this last week, that in Michigan, if you are driving a motor vehicle and you don't have a valid driver's license or a driver's license at all, the wrongful conduct rule does not apply, and a plaintiff injured while operating a motor vehicle without a valid driver's license or a driver's license can still bring a cause of action. The second element is that plaintiff's conduct must be a cause of his or her damages, and the defendant and the plaintiff must be equally culpable, and the statute on which the plaintiff bases his or her claim must not expressly or impliedly authorize a claim by persons similarly situated. There are two exceptions. First is culpability exception, which may apply where both the plaintiff and defendant have engaged in illegal conduct, but parties don't stand in pari delicti, which the transliteration from Latin is an equal fault. Plaintiff engaged in serious legal conduct that approximately caused plaintiff's injuries may still recover against defendant if the defendant's culpability is greater than plaintiff's culpability for injuries. The thing that comes to mind is one drunk driver, shame on you. Two drunk drivers, shame on who. That's essentially how we look at this first exception. And the second exception is if there's a statute in place which allows the plaintiff to recover despite wrongdoing. A few years ago, we had two neighbors who were going at it. One of the neighbors came out with a bat, and the bat-wielding neighbor said, "If you step on my lawn, you'll pay for it." So the neighbor stepped on his lawn. He was trespassing, and the defendant took the bat and the defendant hit the plaintiff on the head with a bat. The illegal trespassing was not enough for the wrongful conduct doctrine to be applied, and the case went forward against the bat-wielding neighbor. We have related additional defenses, as I've mentioned, in pari delicti. As to parties who are equally in the wrong, the law will not lend itself to afford relief to one against the other, but will leave them as it finds them. It goes back to two drunk drivers as the example. Here we've got the wrongful conduct rule, which Michigan obviously applies based upon common law principles, which applies to bar a plaintiff's claim when the action is based on illegal conduct. And in those instances, a party may not maintain an action if, in order to establish the cause of action, they must rely in whole or in part on an illegal or immoral act or transaction to which he or she is a party. We had a case about maybe 7 years ago where a plaintiff sued a gentleman's club for contracting an STD from a dancer who he apparently took in the back for private dances and paid for extras. And obviously the court found that he was engaged in illegal and immoral conduct and dismissed this case. Next, we've got the Orzel case. The wife as guardian of her husband brought suit against the pharmacy for allegedly negligently supplying, the way I'm pronouncing it is Desoxin, thank you, if I could read my own writing, which is a methamphetamine for ADHD. It's highly addictive, and the husband caused physical and psychological, or had physical and psychological addiction to the drug, and had serious mental illness. The circuit court entered a judgment on the jury verdict in favor of the plaintiffs, but found the drug user to be 50% negligent and entered judgment under the wrongful conduct doctrine. The Michigan Court of Appeals reversed. The Supreme Court held that the drug user's claim against pharmacy for allegedly negligently and illegally filling drug users' purportedly valid prescriptions was barred, since it was based, at least in part, on the drug user's illegal conduct. So when we see these pharmacy cases, we typically see the plaintiffs who become addicted, they shop around for doctors to fill scripts, they change the quantity or the date on the scripts. They may go to a different state to get the scripts filled, because as I mentioned earlier, Michigan has a way of tracking prescriptions, controlled substances, which is MAPS. In Ohio, they have their own system, the Ohio Automated Prescription System. So this plaintiff was essentially equally, or if not equally, but more at fault, and his case was dismissed. Next, we have the Cherajewski versus Costco Wholesale Corporation case. This customer had been on the premises before a couple times, stole some cameras. This time he went in to steal some cameras. He had a razor blade or a pocket knife of some sort, and he couldn't get the cameras to open, but he was walking out with a stolen 7-inch television, and he greeted the greeter on his way out, and one of the employees came out and tackled him and called the police, and he filed suit based upon assault and battery. And the Court of Appeals held that the district court erred by not engaging in complete analysis. So the lower court should have determined or made a determination as to the wrongful conduct doctrine and whether it applied, and if so, to the extent in which it applied, and whether it should have been a bar to the case. We next have related additional defenses. So going back to the Costco case from the prior slide, the person who engages, actually the actual code states that a plaintiff may not sue for bodily injury or death suffered during the commission or flight from the commission of a felony. So in the Costco case before, with the gentleman leaving with the 7-inch television, he didn't have to know that he was committing a crime that's considered a felony. Shoplifting can be considered a felony. He was charged with unarmed robbery, which is a felony. So the wrongful conduct rule did apply there. And then next we've got the sudden emergency doctrine. It's a judicially created principle that was defined in Cooney Vacuum versus Marvin back in 1946. What is it? It is essentially something that's unforeseeable. So if for instance, you take off with a brand new car from the dealer and the brakes fail and you rear end someone, that is something that's not foreseeable. Having a heart attack while driving, if you've never had any heart issues before, that's something that's not foreseeable. But if you had just left the doctor's office and you were told you may want to take it easy, you may not want to drive, and then you have a heart attack, you rear end someone, the sudden emergency doctrine does not apply. Same thing with buying a used car, being warned or having a mechanic check it out and saying, well, there's issues, you need to get this fixed. The sudden emergency doctrine wouldn't apply. Similarly, if your brakes were already squealing or squeaking because they needed to be replaced and you did not replace them and your brakes go out, you rear end someone, the sudden emergency doctrine does not apply. So the Michigan Supreme Court has used the word unusual or unsuspected. So the examples that I gave, again, back to the heart attack, the brakes, the medications, if it's unsuspected, the sudden emergency doctrine does apply. And if it's unsuspected, same situation, it does apply. Next, we've got presumption of negligence. Like most states, even in a rear-end accident, like most states, there is a presumption of negligence on the part of the party who rear-ends another vehicle. However, even in a rear-end accident, comparative negligence does apply in Michigan. So tying this back together to the sudden emergency doctrine, plaintiff's motorcycle collided with the rear bumper of a vehicle, which then fled the scene of the accident. Plaintiff hit the rear bumper of the vehicle after the vehicle suddenly braked. The accident occurred during rush hour on freeway. So the plaintiff was on a motorcycle. There's a presumption against him that he was negligent because he rear-ended another vehicle. But there was a witness, and the plaintiff testified that the driver of the other vehicle that was rear-ended was doing what we call a brake check. He slammed on his brakes to harass the motorcyclist. So the sudden, the comparative negligence in the rear end accident, there was not applied to the motorcyclist, although there is case law that states that Michigan law does not require anticipation of erratic driving, so that also helps the motorcyclist out. And in some cases, it's the judge who decides whether the sudden emergency doctrine applies. In others, the judge will say it's a question of fact for the jury to decide. We had a fatal motorcycle versus truck accident case. Our truck driving defendant and trucking company, brand new Freightliner, had about 700 miles on it, suddenly stopped on a highway, one lane each way. And as our client, the defendant truck driver, he had his hazards on, he had the reflective tape on the back of the ITC bar on the back of his trailer. He was putting out his cones, and out of nowhere came this, what we essentially use this, I guess it's not really a term of art, but it is for the judge, a crotch rocket, which was going about 125 miles an hour, couldn't stop and slammed right into the ICC bar. The only thing that was visible was a helmet. You couldn't tell there was a body there or a motorcycle. The judge actually granted the motion on both bases, A, the sudden emergency doctrine, and B, the wrongful conduct doctrine. And on that, we do have a Michigan civil jury instruction that's on point, which is an excused violation of statute, which applies to both plaintiffs and defendants. And with that said, Rick?
Well, I mean, we talk about this excused violation of statute, which really is a different sort of defense. When you start out with a violation statute, which is a potentially negligence per se, no more proofs would be necessary other than to prove that you violated the statute. This is the fail-safe argument. This is the last resort for the defense to be able to say, look, no matter what we could have done, no matter what we could have done or should have done to try and comply with the statute, it was beyond our control that we violated it. The most prominent example usually is weather conditions. Often the idea that you hit a patch of glare ice on an expressway but without other warning is an appropriate defense to a rear-end accident. So under the circumstances, you have the opportunity applying this common law defense of excused violation as recognized by the jury instruction to be able to still put on a defense even in the face of a presumption of negligence. With that, John, do we have any questions?
Yeah, we're going to take it away now. We've covered a lot of territory here. So I'll just remind everyone that if you'd like to ask a question, you want to do that by entering your question in the window, the questions window of the webinar desktop interface. We'll give everybody a minute to do that. I know there was one that I saw earlier. Let me get that question. This question is related to recklessness versus carelessness. And it says, who decides whether it's recklessness versus carelessness for the assumption of risk?
Well, ordinarily, that's going to be a question of fact for the jury. It's only in the most extreme circumstances that, in most cases, that you're going to be able to assemble enough facts to be able to persuade the judge to take that question away from the jury. However, it is possible in those instances to be able to do that, but it seems most unlikely, and it's really going to fall to the question, to the trier of fact, the jury in that instance. Great.
Again, just if you want to ask a question, you want to use that questions window. There is one more here, and if we don't get any others, we'll wrap up. Is there really an excused violation of the statute rule?
Well, as the instruction says, if you've done everything that you can and still violate the statute, done everything reasonable, that's a defense. Now, this is not, even though it's in a jury instruction, it's not statutory. It's really common law. It's really the life of the law, the common sense of the law that applies it in this instance. We can see it not just in the automobile context, but even in the landlord-tenant slip and fall context. And virtually any negligence claim where there's a potential to use a statute as an allegation of breach of duty, causation, and negligence, you can still fall back on this common law doctrine of excused violation to present a defense.
Great, thanks for that. I don't see any further questions, so I'll start wrapping things up. If I see anything else pop up here, I'll give a shout. So let me wrap up by saying that following today's presentation, there's going to be a survey emailed, a link actually, emailed to each of you. So if you could take a couple minutes to complete that, it doesn't take very long. Your feedback's always really appreciated. It helps us think about topics for upcoming webinars. The other thing I would like to do is let everybody know that this group, the Tort Litigation Practice Group, has a blog, and it's located on our website, plunkettcooney.com. A lot of the issues that we cover in our webinars are also covered on the blog. So if you're interested in these areas, it's easy enough to enter your email address. You'll get an alert every time new content's added, and we'd love to have you follow us online. And if you or a colleague would like a recording of today's session, we're going to have that available along with the presentation slides pretty quickly after this session concludes today. So please go to plunkettcooney.com for that. There'll be links there available to you. And on that note, I don't see any further questions, so we're going to wrap up and thank everybody on behalf of Rick, Abe, myself. We appreciate you being here, and have a great rest of the day.
Thank you. Thank you.